Okay, good afternoon, everyone, and thank you for joining us today. My name is Lee Finish, and I'm SUMA's Central Region Director and a councillor for the town of Fort Capel. Before we get started, I want to quickly note the emergency exits and AED locations are marked on pages 24 and 25 of your handbook. We want to make sure that all delegates are safe, so when you have a minute, please familiarize yourself with this information and expect to be reminded a few more times throughout convention, as your safety is very important to us. Please note this session is being audio recorded, and that means if you want to ask a question, go to the mic, identify yourself, your municipality, and speak clearly into the microphone when asking your question. Using the microphone means that everyone in the room can hear you, including our speakers, and the question is on the recording. Later this month, the presentations will all be available on the SUMA YouTube channel, and we want the recordings to be a good resource, so we need all questions recorded. When we plan events for our members, we try to tailor the topics and speakers to your needs. The full bios of our speakers today are available on EventBase, our convention app, where you can see the work these folks have been putting into gaining the knowledge they're going to share with you today. Please give them your full attention and be open to how their information can apply to your municipality. Some lessons are going to be easier to apply than others, but I'm sure everyone in this room can use the valuable nuggets of information when you go back to your constituency. As a first note, this session is being sponsored by Great West Life, and we thank them for it. I am now pleased to introduce our presenters. Ronald Kruzeniski, QC, is the Information and Privacy Commissioner of Saskatchewan. He was in private practice for 16 years, during which time he was Chief Commissioner of the Human Rights Commission. He also practiced law in the Ministry of Justice, and in 1995 was appointed the Public Guardian and Trustee. Ron was appointed Saskatchewan Information and Privacy Commissioner in 2014. Mary McFadyen, QC, is the Ombudsman and the Public Interest Disclosure Commissioner of Saskatchewan. She has extensive experience practicing with the Department of Justice of the Government of Canada, first as Counsel, War Crimes Section, later as Senior Counsel Coordinator of the Criminal Conviction Review Group, and then as Director General Legal Services for the Office of the Ombudsman for the Department of National Defence and Canadian Forces. Just prior to her current role, Mary was Deputy Registrar of the Supreme Court of Canada. Thank you both for joining us today. Delegates, please give our presenters a warm welcome. Mary will be first.
Thank you very much, Lee. It's the first time I've been introduced where people have been told how to get out of the room before I started talking. Usually that happens after I've talked for about 10 minutes, so anyway. Thank you, everybody, for coming today. Just a quick show of hands. Who are council members? Who are admin staff? Okay, good. Just wanted to have a quick idea who the crowd is. So usually when I come and talk at any municipal organization events, it's always about conflicts of interest in council members. So today, I'm not talking about that. We're talking more about the obligations that council members have under legislation to conduct their business in an open and transparent manner, and how they have to do this under municipal legislation, and then how the Freedom of Information and Protection of Privacy legislation can impact on those obligations you have under the municipal legislation. So this is the agenda for today. I'm going to talk a little bit about the Ombudsman's role and how we do our work, the types of complaints that we get with respect to openness and transparency in municipal government, and how municipalities, people allege that they're not forthcoming with how they're conducting their business, and hopefully give you some suggestions about how you can comply with municipal legislation to ensure that you're being seen as governing in an open and transparent manner. And then I'm going to hand it over to Ron, and he'll talk about the role of his office and how I want to say LaFoipa, is that how we say the FOIP? LaFoip? How your obligations under that have to complement your obligations under municipal legislation. So we'll both talk pretty quickly, and then we'll leave time for questions. There we go. Okay. So this is just a brief summary of what an ombudsman is. So we have the mandate to take complaints about provincial and municipal government organizations and how they carry out their duties and how they make the decisions. So we review complaints to see if the people that complain to us have been treated fairly and in a fair and reasonable manner under the law. So our powers are set out in our act, the Ombudsman's Act, and the act is very, very wide. It gives us wide powers of investigation and ensures that we have the independence to conduct investigations and make findings, conclusions, and recommendations. So the Ombudsman is an officer of the Legislative Assembly. So what that means is that we are not part of the executive government. We're not part of any of the ministries or agencies that we have the right to take complaints about. Specifically, we do not report to the Minister of Government Relations. We sometimes get complainants who are mad at how we've treated their complaint, and then they complain to the Minister of Government Relations, who doesn't have the authority to tell us how we are to conduct our business. So in simple terms, what our role is, so we have the Legislative Assembly that we elect who makes laws. They pass all the legislation. And then it goes over to the executive government, the provincial ministries and agencies and local governments. They have the role to carry out the legislation on behalf of the Legislative Assembly. So our role as the Ombudsman is we make sure that the powers that are given to those organizations under the legislation is carried out fairly, reasonably, and according to law. So that is in a nutshell what our role is. So we can investigate, as I said, provincial government agencies, crown corporations, the health authority, any publicly funded health entities. And then we can take complaints about municipal entities, so that's any municipality under the 3 municipal acts. And we can also take complaints about council members. So just to give you an idea, so that changed in November of 2015 that we can take complaints about municipalities. So before that, there's about 200 municipal or provincial organizations like ministries, agencies that we can take complaints about. So when the Act changed 2 years ago, now we can take complaints about the 778 municipalities and the 4,400 plus council members. So it really expanded our mandate. So I just want to stress that it did make a big change to our office. So that's who we can investigate. So what we can investigate is we look at how administrative decisions are made. So we can look at any act that aggrieves a person, so any act, decision, recommendation, or omission that was done by any of those organizations when they're carrying out any duties that have been given them under legislation. And really our role is to improve government decision-making processes. We review how decisions are made, and we make recommendations that are aimed at improving how government carries out their duties, so that they make their decisions fairly, reasonably, and according to law. Okay, so this is a very quick sort of brief way about how we take complaints. So we get over 4,000 complaints a year. Someone comes to our office, we try to triage them. First we try to do is we see if it's something within our jurisdiction. So if it's an entity within our jurisdiction, a matter within our jurisdiction, then the first thing we have to find out is is there any possible avenues of appeal or review that the person has that are available that they can use? And if they do, then we have to, under our legislation, refer them back, because an organization should be able to fix their own mistakes before the Ombudsman gets involved. So if they've used those processes and they're still not happy, then we'll look at it and see if there's a role for us. We would try to resolve it first if we could, and we usually, about 80% of the cases that we get, we are able to deal with them very quickly like that. If not, then we will look at it closer to see if we should investigate. And if we investigate, we do it very formally. We'll issue a formal notice. We will investigate, we'll interview people, we'll look at documents, we'll prepare a report, give the parties an opportunity to review it before we finalize it. So that's how we carry out our work. So our role generally is, again, we review a complaint. Our role is to make improvements to how the government organization we're looking at is making their decisions. So it might not necessarily change the matter for the person who's brought the complaint to us, because that's already happened, but we hope to improve the processes so what happened won't happen again. And our role is to make sure that municipalities have good processes in place. Our role is not to chastise them. We are not a court. It means we do not have the power to fire a council member or to quash a bylaw or to overturn a properly made council decision. Those roles were not given to us. Our role was to investigate and try to make recommendations to improve government processes. And we're not an advocate, we're neutral and impartial, so we're not an advocate for the person who brings the complaint to us or for the municipality that we may be investigating. We look neutrally at the facts and determine if there's any recommendations we can make to improve the process. So that's in a nutshell what we do. So now we'll get to the types of complaints that in the 2 years since we've had jurisdiction, and in 2 years we've received over 1,000 complaints about municipal government. So just to give you an idea of the types of complaints that we get, and maybe some suggestions about how you can go about alleviating it so that people will not contact our office about these things. Okay, so the first complaint is we get people phoning us who the council's holding a meeting and the public don't have notice that it's going on. So we get allegations that council is conducting all of their meetings without notice so that the public will not attend. Has anybody heard that one before? Had that allegation? No, nobody here. Okay, well, we get a lot of this. So under legislation, you have to be publicly accountable. Any actions or proceedings that a council does, it is not effective unless it's authorized or adopted by a bylaw or a resolution in a duly constituted public meeting. So you are required to hold your meetings in public unless it fits under the exceptions that are under the acts. And if you have a regular meeting schedule, the act says that you do not have to give notice, but if you change a date, then you have to give notice at least 24 hours ahead. And really, it's sufficient if you've posted it at the office or on any way that council has specified in a bylaw to give public notice. But really, a recommendation that we like and that we see is if your agendas are online. It's just an easy way for council to have it and for the public to have it. Okay, second one. They're not allowing me to speak at a public meeting, and I have something very important to say. I'm sure you've all seen this one. So the public has a right to attend at a council meeting, but they do not have the right under the legislation to automatically speak. And the council has the authority to determine the rules for when, how long people can speak at a council meeting. And these delegations, we know they can be critical of a decision or direction that council's taking, but that's not a reason to not let them speak. So under your procedures bylaw, it says that you have to have rules respecting delegations and presentations and submissions. And the bylaw should include a process that delegations should follow and timelines for them to be put on the agenda to speak at something. And really what we've seen is make sure that you apply the same rules to everybody who's making an application to be on council, or to speak before council. So don't apply it, if you have rules in place under your bylaw, don't apply them very strictly to somebody because you do not like what they're saying, but maybe a little bit more lenient for somebody that you do appreciate what they're saying. So just make sure that you apply it consistently when you're dealing with people that want to make delegations or presentations at council. Okay, complaint number 3. They have been banned at speaking forever at a council meeting, not just on the specific issue they've raised, but they are banned forever. We've seen a few of these at the office. So just because you don't like what someone is saying, they still have a right to be heard. But if someone is abusive or being unreasonable to deal with, we all deserve to be treated with respect, and the legislation does allow you to expel somebody for improper conduct at a council meeting. But you do need to make sure that your decision to ban someone is done using a fair process and that you're applying it consistently to everybody that you deal with. So think about having a rule that what qualifies as being a disruption during a meeting? Is it an outburst? You're not following the time limits? And define what it means when you are temporarily banning someone from a council meeting. Is it on a specific subject? Is it set for a ban for a certain number of time? And can you have it reviewed? So usually when we do this, sometimes we get people, I know you'll find it very hard to believe at our office, who are not nice to us and unreasonable when they contact us and abusive. It's hard to believe, isn't it? So what we do if they're being very disrespectful, they're swearing at us, abusive, we give them a warning, say, listen, this is not appropriate. You know, you need to be respectful when you're speaking to us so that we can assist you. One warning. After that, then we will usually ban them and they can only contact us in writing. And we always say that it can be reviewed. So it's not forever. You know, they have an opportunity in 28 days, we'll look at it again. So just sort of some things to think about when you have this issue of banning people from your office. Okay. This is a big one too that we see. I should have done this in the top, like, you know, David Letterman's top 10 list. Council is dealing in matters in a closed meeting that they should be dealing with in public. So, of course, you are required under the legislation to deal with matters in public, but you can close the meeting or part of the meeting if you're talking about long-range planning or any of the matters that are under Part 3 of the Local Authority and Freedom of Information and Protection of Privacy Act. So your procedures bylaw should have rules and procedures for when you will go in camera or have a closed session. And remember that you can't make a decision in the closed session. You have to close the closed session and then you have to come into an open meeting and make any decisions that have to be made because it has to be made in a duly authorized public setting. So we do get complaints about this, that council's talking about something in private, and really we look at the evidence. Is there any way, so they say that council is meeting in private about something they shouldn't be. So I mean, we look at, you know, what the agenda says. Does it clearly say in there why they're meeting in council, or meeting in, you know, in a closed session? And then afterwards, was there a resolution made to deal with the decision that was made after the closed session in a public matter? So here's a few suggestions about, you know, that you have to be, there's a right to conduct business not in a public meeting in a closed session, but you should be transparent as possible about it when you're doing it. So give reasonable notice, put it in the agenda that you're going to do it, make a clear resolution during the open session about what you're going to be talking about in a general matter, that it's a HR matter, not that you're firing Joe for, you know, doing something bad, but a general thing. Pick the right exception, keep very good records, and make sure you stay on topic when you're in that meeting. So don't get into something that you should be discussing in a public meeting in that private session. And so then when you come back, always, as I said before, make sure if you make a decision there, it has to be authorized when you're meeting in public. Okay. This is a common one. This might be maybe one of the top ones that we get here. So refuse copies of documents, or it took too long to get copies, or it was too expensive to get the copies. So people phone us, they can't get access to agendas, to meeting minutes, to people's public disclosure statements. Those are the types of issues that people come to us. So under the legislation, certain records are deemed to be public records that have to be available for public inspection during regular business hours. So that's any council-approved contracts, bylaws, resolutions, public disclosure statements, oaths, financial statements, approved council meetings, consultant reports, except for lawyers. You can tell that lawyers wrote the legislation because they're accepted from that. Anyway, and it also says that council has to, they have to be provided within a reasonable time and at a reasonable fee. And it's the administrator's duty under legislation to give access to these public records. And this goes hand in hand with the administrator.
First of all, responsibility under 3 statutes. The first is the Freedom of Information and Protection of Privacy Act, which we short formed to FOIP. It was introduced in 1992. The second one that is more important to you is the Local Authorities Freedom of Information and Protection of Privacy Act, which we reduced to LA FOIP. And it was introduced in 1993, so it's some 25 years old. And finally, the Health Information Protection Act, which we call HIPAA, which was introduced in 2003, so some 15 years old. Under all those 3 acts, we review decisions made by public bodies, in this case local authorities, and cities, towns, and villages are local authorities. We also, so decisions, if you decide to withhold giving a ratepayer certain documents and he appeals to us, then we will review that and make recommendations to you. The second thing we do is investigate breaches of privacy. The third thing we do is comment upon legislation as it proceeds through the Legislative Assembly. And finally, we do some education and speaking regarding rights and obligations as we're doing today. So next I want to briefly talk about our two processes. We have one process where we're reviewing basically a denial to access to documents. So someone comes into the office and requests a series of records. And if the records are provided, well, the citizen is happy and nothing happens. If you provide some of the records but withhold others, the citizen can be upset, can do nothing, or choose to request our office to do a review. Once we get a review, we first try to resolve the matter, narrow what they're asking for, clarify what they're asking for. If that attempted settlement doesn't work, we issue a notice of review, which tell the parties that we're going to review this matter. And we usually ask the public body, the city or the town, for a copy of the records that are in dispute and their reasons as to why they aren't being released. We do our analysis, we do a draft report, we send that draft report to you, ask you for any factual errors or comments, and then we issue a final report. And in about 3 or 5 days, that report is on our website. Now, the next process is very similar, and this is when there's been a breach of privacy. Now, those breaches of privacy can come to us in varying ways. One way is somebody is upset and they come and they complain to us. Another way is we hear about it in the media. And a third way is the public body, city, town, or village, comes to us and says, by the way, we've had a breach. We call that self-reporting. We do encourage that, and we find that that probably works best for public bodies and for us. And because it means we start working together and saying, well, the breach occurred, but how can it be prevented in the future? If we get a complaint, we usually ask the town or village to do an investigation on their own and let them determine what went wrong, if anything, and then provide that report to us. We then issue a draft report, get reactions to it, and a final report, and it goes to our website as above. Now, the next slide is who do you call? This area is an interesting area and complex enough, and if you've only been exposed to it the first time or once a year, you're probably going to need some assistance. And I'm going to talk about this later, but for starters, I really encourage you to call Mary's office or call my office. You may not know exactly which one to call first. That's fine. We certainly direct inquiries between our offices. So if you've called my office and it has to do with, say, an issue of fairness, and it has nothing to do with a breach of privacy, then my staff are certainly going to recommend that you call Mary's office and give you the phone number. Next, I want to talk a little bit about open and transparent, and this session was labeled Shining a Light. And in a democracy, we really need our tax-funded organizations to be pretty open and transparent. We as citizens need to know what's going on. We need to be able to form opinions, and at some point we need to be able to vote. And when you're part of an organization, it's sometimes more difficult to think about it that way, especially when you're in the middle of a dispute. But think about some organization that you have nothing to do with, that's tax funded. say like the province, and don't you, as you hear the news, saying, we need to know more about that. And that's generally what applies to your organizations too. And it kind of applies to all government agencies, ministries, crown corporations, on and on and on. Mary touched on some of these, and I'm going to move quickly. But in the next one, it starts with what? Having meetings that are open to the public, having minutes that are available, committee meetings that are available, having policies and bylaws that are available for people to access. Of late, one's come up of recording at meetings. And I think this first arose in the school board's context. In my opinion, if I have a right to go to the meeting, I should have the right to pull out my cell phone and record it a bit. Should someone be obstructionist in the process? No. And one way of controlling that so that it's done in an orderly way is deal with it in your resolutions or bylaws. Another thing you can think about is how much goes in camera. Everybody needs some issues to go in camera, but is there the temptation to have too many things going in camera? Again, by resolutions and bylaws, your council can figure out just how open they want to be, what's reasonable to discuss in the public, and what does need to be discussed in camera, and then a resolution passed in public. Just to refer to a couple of things that support the authority for this, in the next slide you have the Municipalities Act, Section 120, and really this is the mandate to have meetings open. Note on the slide there, refer to the Cities Act and the Northern Municipalities Act. These acts pretty well have parallel provisions, and the slides try to refer to all three. If we go to the next slide, access to documents. Section 5 of LA FOIP basically says a citizen has a right to any record that a local authority generates. Now, I'm going to emphasize that doesn't mean that you're forced to create a fancy table or a spreadsheet. It means records that exist. And they can make an application to get that and have a process to basically have access to it. Now, on the next slide, in the Municipalities Act, that's reinforced here by the Municipality Act, a section that's probably been in force longer than LA FOIP, and that's 117. And in that, it lists some of the things that are public. The first one is contracts approved by the council. I do want to come back to contracts because that is an area where some contention arises. Financial statements are available, and another one, I suppose, where contention can arise is reports delivered by consultants or by employees of the council. So this just reinforces what LA FOIP says, but two pieces of legislation that says records and documents are available to individuals. The next slide talks about, do you have a website? If there's an obligation to make these documents public, how do you make them public? Well, in the good old days, people would come to the town office, ask to inspect them. As photocopiers came along, they could ask for copies. I assume most of you have a website. If not, I encourage you to think about developing one. I think it's a great vehicle for showing that one is open and complying with the legislative requirements. It can make you look and be as transparent as you want to. It also can reduce the requests of people coming and asking for copies of minutes or agendas or contracts. The town of Kindersley has what I think is an excellent one. Not that I've surveyed all of them in the province, but if you're looking for a template of what a town is able to do, that is certainly a good example. You may want to have a policy or bylaw on what goes up on the website. It's usually staff that are going to be doing this, your administrator or other staff. They need some guidance. I don't think they want to post something and find the mayor there the next day saying you shouldn't have done it. Give them the guidance through the bylaw, the resolution. Now, one caution, as you put documents up on a website, they can contain my personal information or your personal or your neighbor's personal information. And there is an obligation to protect that personal information. So from time to time, a particular document may have to have some parts of it redacted or left out just because of the personal nature of the document. I wanted to move on to contracts with businesses. First of all, I've found that businesses are extremely reluctant to have their contracts made public. And they will resist it, and usually resist it by wanting the entire document to be public. LA FOIP really allows citizens to request a copy of that contract. The Cities Act and the Municipalities Act basically reinforce that. Contracts are to be made public. That also includes the invoices that might relate to that contract. Now, what businesses will say is, I have proprietary information in that contract. I have trade secrets in there, and I do not want my competitors to get a hold of them. Now, the trick is, at the time of drafting the contract, think about what really needs to be in there that is proprietary or a trade secret. And if it really does need to go in, think about sort of segregating the sensitive information, the trade secrets, into an appendix at the back. I can tell you that in a contract in clause 9 or 19 that says the singular includes the plural and the plural includes the singular is never going to be protected by my office. There's nothing trade secret about clauses like that. So in most cases, a good portion of the contract is going to be recommended to be released. So a good drafter of a contract would say, well, maybe this contract will be released, but maybe there's some arguments why the stuff in Appendix A shouldn't be released. Let's put it in Appendix A. We may have arguments about that, but we won't have arguments about the whole contract. The next item or next slide is about access to residents' information. As I said, LA FOIP, provides for access to records, but it also says a town or village must protect my personal information or your personal information. Now, the problem is, in the process of making decisions, it's necessary that council have access to some, if not all, of my personal information. Maybe I wrote in regarding whatever, and in my letter I've disclosed some of my personal information. I think the caution is, as administrators and others develop the documents around it, look at how much of that personal information is really needed to make the decision, minimize it as much as possible, de-identify it as much as you can. The simple example is, if you're referring to somebody's vehicle, do you refer to a 2016 Honda CR-V license number XYZ, or do you refer to a vehicle that was parked at the wrong place? How much information is really necessary to make the decision? Similarly, in minutes, when it comes to that personal information, can it be de-identified? And then finally, very conscious of what you do with the website. Again, to assist your staff, what about rules or policies around the approach to your documents and to personal information? So councillors are residents too. So a councillor, a mayor, has, under LA FOIP, all the rights that a resident would have, and can request information. But another question arises, as a counselor, what information is required in order to do your job properly? And again, I would suggest one ought to have bylaws or policies or codes of practice around what counselors are entitled to. How much information is necessary to make decisions, what should they have access to and what shouldn't they have access to. The Municipalities Act kind of deals with this too in Section 92. And really there, what it's saying, well, and I should say, I have heard the comment, yes, but if certain counselors have information, they're going to talk about it to others. Now, that can be a problem, but Section 92 is partly there to deal with it, that information is treated as confidential until discussed at a public meeting. So that is sort of an expectation, an obligation imposed upon every councillor. Also, if you look at the Municipalities Act, Section 81, council can create a code of conduct. I'm presuming many of you have a code of conduct. If you don't, certainly consider one. And in there, you can develop the confidentiality clauses that are necessary that allow business to go on in your particular municipality. Next, I come to fees. Mary talked about fees. LA FOIP has fees, $20 for an application, plus some costs for reproduction and searching, etc. The Municipalities Act also contemplates that a council can charge reasonable fees. So the authority is there to charge fees, and council needs to make decisions as to, if I'm a taxpayer, what am I entitled to for free? On the other hand, when have I gone so far that I'm starting to put a bit of a burden on the town, and I should be required to pay for it? You can make bylaws on this too, and then the key question, if I'm a counselor and I ask for information, should I be charged for it? Is it fair that as a counselor, to do my job, I need information, but I'm charged a copying charge? Now, you might say, hey, it doesn't happen in my municipality, but it's in my notes for a reason. In other words, we've had the issue. Finally, I get to personal emails. I call this the Hillary Clinton matter with personal servers, and it has arisen in other jurisdictions. And really, as a best practice, I would encourage all councils to talk about having a separate email for your council business. When you start to mix your personal life, your business life, your political life, and your council life, it's going to get messed up. If things get on a smartphone, and you only have one smartphone, do your children have access? Does your spouse have access? Who has access? And if you get emails that have personal information, you've just allowed other people who don't have authority to have access to that information. So the best practice is keep affairs separate. Your council emails and information are part of can be part of the council bookkeeping system, and if they're on the server, then they get stored properly and deleted properly when the time is right. You can extend that into cell phones, and I think you'll see documentation out there that you keep your personal cell phone in this pocket and your business or council cell phone in this pocket. You might say that's a lot of work, but I can see a trend where people are walking around with two cell phones so that they keep their record keeping separate. Who makes decisions? LA FOIP says the head makes certain decisions. The head is the mayor. Now, under the Municipalities Act, there is the part that council makes the decisions. But LA FOIP says the head makes the decisions. Now, if the mayor, is probably as most mayors are, busy people, have their own businesses, have their own involvements, not in the office every day, that can be delegated to the administrator. And if council are going to delegate it, then I would suggest a resolution that basically authorizes the administrator to deal with these things. And in some instances, I would say without bringing them back to council. Because at that point, then you've taken the decision away from the head or the administrator and put it in the hands of council. But if you put it in the hands of council, there's certain deadlines and you may have to move rather quickly or you'll miss the deadline. So back to getting information. Encouraged you to call Mary's office or my office, and if you call the wrong one, we'll direct you to the right place. You have some other places to call. SUMA has a legal department, and I'm sure many of you know Steve. And I highly recommend you call Steve. Number two, okay, I'm trying to ensure that Steve has employment for life. There's other places you can call. The Ministry of Government Relations has a unit of, I'm not even sure how big, of 3 or 4 people that are there to answer your questions. And they're pretty familiar with LA FOIP and the Municipalities Act, that sort of thing. The Ministry of Justice has an access and privacy branch, and you can get information there. And you also have private counsel. My only caution with private counsel, please ensure that that counsel is familiar with LA FOIP and the rules. If they don't know what LA FOIP is, you run the serious risk of getting advice that will probably just slow down the whole process and cause you to be frustrated. So, and again, Mary and my offices are there, and we're always glad to point you in the right direction. So I'm going to close by saying we decided to have an exhibit here, a table, and we bought some swag, and I wasn't going to authorize buying these. If you can see them, they're a floppy head pen. They were the best seller ever. And I don't know, but I'm worried that some of you didn't get there, so I've got 4 more left. So if you have a cute little grandchild that you really want to give one, come and talk to me after. Thank you very much for listening.
Resolutions. So if anybody has any questions, I would encourage them to go to the microphone.
Nicole from the town of Rostern. I was told by another administrator who was having issues, she had to take information out of her minute resolutions, and it was pertaining to names. So if we get a letter from a ratepayer, we can't use their name in that resolution. So how do you identify the person?
I'll let Ron answer that since it's taking out private information.
One always has to strike a certain balance in these things. And if you're passing a resolution that pertains to a particular person, there may be absolutely no choice but to name that person because they were approved for a grant or a rebate or whatever the letter considered. On the other hand, you may not have to put in the address, the age, the sex, the family status of that individual. So I would say in those instances, use all your discretion to use the minimum amount of information. This also, I'm going to toss it to Mary to see if you have any supplementary to add to that, but I think it's use your best discretion and use the least amount possible.
Yeah, again, under our rule is we look at whether or not municipalities have carried out their obligations under the Act, so they have to keep good records. We know that the privacy and access legislation complements that, but still you have to be able down the road, so if in 2 years we're looking at a case where someone has claimed that they weren't treated properly, and we have to figure out when a decision was made by council, there has to be enough information in there so that we can determine what was done or not. So it probably is a fine line about what should be put in and made available, so that there is a record of what decision was made. Especially when it's a decision that's been made in a public meeting where everybody's there and has heard it, or some councils videotape their meetings and they're on, like Regina, it's on the Access 7 channel, so everybody can see if somebody comes to council. So it is, it's a good question about how much should be in there and what actually is it personal information when somebody comes to council because their garbage cans didn't get picked up properly? Would that be considered personal information of a resident?
Yeah, this was just the name.
The name.
And then that person actually complained to your office.
To the Privacy Commissioner's office.
Yeah, and they were told to put initials in the minutes, so I just wanted to clarify, that position, I guess.
Anything to add, Ron? to
No,
that?
no.
Just use your discretion.
Ron Kowalczyk, Mayor, Town of Hafford. It's you have an open meeting and you have delegation, and you allow them to come make their presentation, what they want the council to, what the complaint they have. Council handles it to make a unanimous decision. How often can that person keep coming back to meetings and ask for the same thing to be changed?
Well, I would suggest, and what we've seen is that lots of councils in their procedures bylaw actually deal with that issue up straight front. So if somebody's already raised it at a council meeting, they can't raise it again for 6 months. So we've seen that, and we've had people complain to our office that they didn't get a chance to speak, and when we've got a copy of the bylaw, we've looked at it, and it's limited people. They couldn't speak at a matter if it's been dealt with in the last 6 months and a decision's been made, and so we have determined that they had the right to make that bylaw, and it wasn't unreasonable, and it wasn't unreasonably applied to this delegation, and we felt their complaint was not founded. So you have lots of powers on the municipal legislation to deal with those types of issues ahead of time.
So they come back 6 months and it's dealt with again, and the same result. They keep coming back with the same.
Well, that's their right as a member of the public to be heard according to the bylaw. So, yep, that's part of political life, I think.
Anybody else with a question?
Ron, you talked about the head making the decision. I presume all council made the decision. It could be 4 out of 5 or whatever number. It's not the mayor that makes the decision. Am I correct in that?
No, you're not. And I've had this debate with not with your municipality or your, but with others. Yes, the Municipalities Act says what it says, but LA FOIP is also a piece of legislation, and it says the head makes some decisions. They're not big decisions, but they're decisions to keep the process going. But the head can delegate that to the administrator, and really the wise thing to do is for the head, the mayor, in council to pass a resolution saying, we delegate any powers that the head has under LA FOIP to the administrator. Just take it right out of the head's hands. Now, if the head wants to do it, then the head has certain timelines under the Act that he or she has to meet. But there is it does say the head can do these things, and it names the mayor as the head. So the mayor can choose to take that responsibility or delegate it.
Would that just be for small decisions like what color the wall of the garage is going to be painted, or would that be passing some bylaw?
Well, if I understand your question, passing bylaws, you would have to make in accordance with the Municipalities Act, which would be the council. Under LA FOIP, it has a thing like someone makes an access request, and the head can decide not to release some of the documents. So you see how you could delegate that to the administrator. When my report is sent out to the head has 30 days to decide whether to follow the recommendations. Now, in that 30 days, the head could take it to the next council meeting and say, that Kruzeniski, he's crazy, I don't recommend we follow these, and pass a motion. That's fine. But after the 30 days, the head is supposed to write and say, I'm following recommendation 1, we're not following recommendation 2, and we're thinking about following recommendation 3. His obligation is to get that response out, his or her obligation. But how he gets to that decision kind of depends on the internal workings of your council, and he has 30 days to do it.
Just a final question in terms of contract details for staff in the minutes. So Johnny Blow has been hired at a wage of $23.62 per hour, period. That's quite acceptable, I presume, and in fact necessary?
You're saying that would be an actual resolution?
Yes, that would be a resolution. In a small council, sometimes you only hire one person every 2 months or 2 years even.
Well, you have some choices there. As the earlier question, if you craft your minutes in such a way, you could probably say, council approves the contract hiring Johnny. The contract may be a one-page contract that says Johnny is hired for 40 hours for 3 months at $23 an hour. Now, if somebody asks, that contract is releasable. If you post all your contracts to the website, that contract will be there. But the minute itself can be reduced to the minimum. If, I guess, you decide to make your minute the whole contract itself, then it's going to have a few more details in it. But if you deal with the council, you can expect that that information will be public.
Okay, thank you.
Okay, last question. We got about 2 minutes here, 2-3 minutes. Go ahead.
Robert Mardell, Mayor of the Town of Choiceland. This question of the head having the authority to make decisions, correct me if I'm wrong, but still any fiscal or any financial decisions still have to come with a motion from council, and it's only in that way that that decision can be made?
Yes, I'm going to say, yes, I think so, but you're getting into an area where I don't claim to be an expert. When I say the head makes decisions under LA FOIP, that in no way takes away the rules in the Municipalities Act. But there's about 3 things the head has to do under LA FOIP. And I sort of outlined them in the last question. It's those 3 things that the head has to do. Everything else, the mayor has to do according to the Municipalities Act.
Thank you.
Perfect. All right. I would like to thank our presenters for their participation. We certainly appreciate the time. I know everyone in this room, I'm certain, took away a little something from it that they didn't know before. On behalf of SUMA, I would like to make a little presentation to both Mary and to Ron. And I would just like to say that we got a quick turnaround here. Resolution started in about 5-10 minutes. So if we could have everyone head off to the Grand Ballroom as quickly as possible. I'd like to thank our sponsors, Great West Life, for joining us. Thank you.